Section 3401, definition for the term of the Naval Petroleum Reserve that has been given in term 740202, vanilla 8722. For the Title 10 United States Code, the 2 for the Naval Petroleum Reserve, the number 2 meaning for the Naval Petroleum Reserve, commonly for the Beneficia unit that was located in the current county, California, was established executive order present for the date of December 13th, 1912. The term of the Naval Petroleum Reserve, the number 3 means for the Naval Petroleum Reserve, commonly referred to for the Teapot Dome unit located in the state of the Wyoming, established for the executive order for the president dated April 30th, 1915. With the term of the oil shale with the reserve, the number 2 remains the Naval Petroleum Reserve located in the state of the Utah with the established executive order president during December 6, 1916. The term antitrust have the meaning given in term section 1A of the Clayton Act, except that the term also includes the act of June 1936, commonly known as the Robinson-Patman Act. And B, Section 5 of the Federal Trade Commission Act, to the extent of the section applied with the unfair mess with the competition from the term petroleum has been given in the term Section 74203, Title 10 United States Code, Section 3402, Authorization Operations. Amount thereby hereby to be the property of the Secretary of Energy, $22.5 million official year of the 1999 purpose of the carrying out of the activity Chapter 64. 1 of the Title 10 United States Code relating to the Naval Petroleum Reserve, 2 close out with the Naval Petroleum Reserve, the number 1 upon the scale of the reserve, or subtitle B of the Title 34 of the National Defense Authorization Act of the fiscal year 1996, and 3 activities under the relating disposition Naval Petroleum Reserve, the number 2 of the Naval Petroleum Reserve, the number 3, and Oil Shale Reserve, the number 2. B, the period availability funds appropriated with the pursuant of the authorization appropriation subsection A shall remain available until expended. 3403, disposal of the Naval Petroleum Reserve, the number 2 of the disposal of the Fort City lots authorized one subsection of the subject to section 3406 for the Secretary of the Energy may dispose of the portion of the Naval Petroleum Reserve, the number 2 of the located with the towns allowed with the Fort City, California, which are identified with the drill sites number 3A, 4, 6, 9A, 20, 22, 24, and 26 described in the document entitled with the Fort City drill site locations. National Petroleum Reserve 2, accompanied with the maps of file with the Office of the Assistant Secretary of the Naval Petroleum Oil Shale Reserve of the Department of Energy. To the Secretary of Energy should carry out the disposal authorized in paragraph 1 over the competitive sale of the leaf consistent with the commercial practice of the transfer to the federal agency or public or private energy or by such other means that the Secretary considers appropriate. Any of the competitive sale of the lease under the subsection shall provide for the disposal of all of the rights title of the interest of the United States and the property to be made with the Secretary of the Energy may use the authority under the by Act of June 14, 1920. Twix, 1926, commonly known as the Recreation Public Purpose Act, same manner to the same extent that as Secretary of the Interior to dispose of the portion of the National Petroleum Reserve, the number 2 as described in paragraph 1. 3, subsection 2696A of the Title 10 United States Code regarding the screening of the real property other federal use for the disposal shall apply with the disposal authorized in paragraph 1. B is repealed Public Law 10958, Title 331. C, relationship with the antitrust laws of this section does not modify, impair, supersede the operation of the antitrust laws. 3404, disposal of the Naval Petroleum Reserve, the number 3. Minister of the pending termination of the operation, Secretary of the Energy should conserve the administration of the National Petroleum Reserve, the number 3, in accordance with Chapter 64.1 of Title 10 United States Code, such time the Secretary makes the determination for the abandoned oil gas operation for the Naval Petroleum Reserve, the number 3, in accordance with commercial operation practices. B, the disposal of the authorized after the oil and gas operations are banned with the National Petroleum Reserve, the number 3, the Secretary of Energy may disposal of the reserve provided with the subsection 3406. Secretary shall carry out any such disposal of the reserve, sale of the lease, transfer to any of the federal agency. Any sale of the lease shall provide with the disposal of all right, title, of the interest of the United States and of the property to convey with the job to conduct in accordance with the competitive procedures consistent with the commercial practice established by the Secretary. C, relation with the antitrust law. The section does not modify the impair, supersede the operation of the antitrust laws. Section 3405, disposal of the oil shale reserve, the number 2. The definition in section NOSR2. The NOSRT means the oil shale reserve, the number 2, identified with the map of the file of the Office of the Secretary of the Interior. The mob site, the term mob site means the mob uranium milling site located approximately 3 miles northwest of the mob, Utah, identified with the final environmental impact statement issued by the Nuclear Regulatory Commission in March 1996 in conjunction with source material license number SWA 917. Map. The term map means for the map depicting the boundary of the oil shale reserve, number 2, to be kept on file with available to public inspection off the Department of Interior. Tribe of the tribe means for the Utah Indian tribe of the Unitah or you were a Indian Reservation trustee with the trustee, meaning with the trustee with the Mob Reclamation Trust. B. Conveyancing, except as provided in paragraph 2 in subsection 8, all right entitled to the interest of the United States and all federal lands with the exterior boundary of the oil shale reserve number 2, with including surface and minerals right, are hereby conveyed with a tribal to a tribal in fee simple with the Secretary of Energy shall execute, file, in the appropriate office of the deed with the other instrument effectuating the conveyancing made by this section. 2. The conveyancing under paragraph 1 does not include the following: a portion of the Bed Green River to contain earlier in the oil shale reserve number 2 with depicted on the map. The land included in surface mineral rights in the west of the Green River, the oil shale reservoir number 2 with depicted on the map. And C. A quarter-mile scenic easement with the east of the Green River, the oil shale reserve number 2. Condition of the conveyancing for the conveyancing under subsection B, subject to the existing rights for the effective of the day before the day of the enactment of the Floyd D. Spence, the National Defense Authorization Act, fiscal year 2001. 2. On completion for the conveyancing under subsection B, the United States relinquish all of the management authority of the other over the conveyed land, but it include with the tribal activity conducted by the land. 3. With the respect of the land conveyed with the tribe under subsection B. A. With the land shall not be subject to the federal restriction of the alienation. B. Notwithstanding with a provision contrary to the Constitution by law of the Charter of the Tribe or Act of May 1st, 1938, the Indian Mineral Development Act of 1982, Section 2103 of the revised statute, or Section 2116 of the revised statutes, any other law, no purchase, grant, or lease to the other conveyances of the land, any interest of the land with no exploration, development, or other agreement that relating to the land is authorized by a resolution by the governing body over the tribe shall require the approval of the Secretary of the Interior or any other federal official. 4. The reservation of the easement of under subsection B.C. and B2C with the shall not affect the right of the tribe to use to maintain access to the Green River through the use of the road with the easement depicted on the map. 5. Each withdrawal applied of the oil shale reserve number 2 with effect for the day of the enactment of the Floyd D. Spence National Defense Authorization Act, fiscal year of 2001. It is revoked to the extent where the withdrawals applied with the oil shale reserve number 2. Nothing would stand with the 6. Nothing would stand with the land conveyed in the tribe under subsection B shall be part of the reservation with the land of the tribe, such the land with the deed with the part of the reservation with the tribe, purpose of the criminal and civil jurisdiction. D. Administrative unconveyed land with the interest land with the one land interest of the land is excluded with the subparagraphs A and B in subsection B2 with the conveyance under subsection B with the shall be administered for the Secretary of the Interior in accordance with the Federal Land Policy Act, Management Act of 1976. 2. No later than 3 years of the date of the enactment of Floyd D. Spence National Defense Authorization Act of 2001, the Secretary of the Interior shall submit to the Congress over the land use of the management of the land interest of the referred to in paragraph 1.3 of the authorized appropriated Secretary of the Interior such sums of the necessary to carry out the subsection. ECE, the royalty notwithstanding the conveyancing under subsection B, the United States retain with the 9% of the royalty interest of the value of the oil, gas, hydrocarbons, all other minerals produced and saved and sold with the conveyed land during the period beginning on the day of the conveyancing, ending with the day of the Secretary of Energy release for the royalty interest subsection I. 2. Of the royalty payments shall be made with the tribe, the designator of the Secretary of Energy during the oil, gas, hydrocarbons, or minerals are being produced, saved, sold, they are extracted. Secretary of Energy shall retain with the payment of the manner provided in subsection I3. Royalty interest retained with the United States under subsection does not include any development, production, marketing, operating expense. 4. The tribe shall submit with the Secretary of Energy Congress an annual report resource development and other activity of the tribe conveyance concerning conveyancing under subsection B. 5. No later than 5 years after the date of the enactment of Floyd D. Spence National Defense Authorization official year of 2001, and every 5 years thereafter, the tribe shall obtain an audit in all resource development activity of the tribe concerned with the conveyancing under subsection B as provided under subchapter 75 of the Title 31 United States Code. Result with each audit under the paragraph shall be included with the next annual report submitted within paragraph 4. After the river management, 1. The tribe shall manage with the tribal jurisdiction in accordance with the ordinance of the adopted of the tribe land with the tribute with the adjacent within 1/4 mile of the Green River in the manner. A. Maintain maintain the protected status of the land. B. Is consistent with the government agreement, the memorandum of understanding the day of February 11th, 2000, as agreed by the tribe and the Secretary of the Interior. 2. An ordinance referred to in paragraph 1 shall not impair or limited be otherwise restrict the management and use of any of the land not owned, controlled, or subject jurisdiction of the tribe. 3. Any ordinance adopted by the tribe with a reference for the government agreement that may not be repealed and amended with the written approval of both the tribe and the Secretary of the Interior. RG, a plant species, in accordance with the government agreement between the tribe and the Secretary of the Interior of the man for the consistent levels of legal protection in effect of the date of the enactment of the Floyd D. Spence National Defense Authorization Act, official year of 2001. The tribe shall protect the under ordinance adopted the tribe with any plant species that is a listed endangered species with a threatened species under Section 4 of the Endangered Species Act of 1953, and 2 located and found on the oil shale preserve the number 2 of the land conveyed by the tribe. 2, the protection described in the paragraph 1 shall be performed solely under the tribal jurisdiction. H. Horses. 1. The tribe shall manage the protection of the airstrip with control over the horses owned by the tribe of the members located with the found with the oil shale preserve the number 2. Land conveyed with the tribe man with the consistent with the federal law governing with the management, protection, control of all the horses with effect of the date with the enactment of the Floyd D. Spence National Defense Authorization Act, fiscal year 2001. 2, for the management and control protection for the horses described in paragraph 1 shall be performed solely under the tribe's jurisdiction in accordance with the government agreement of the tribe and the Secretary of the Interior. I, remedial action of the mob site of the Secretary of the Energy shall prepare a plan for the remediation, including groundwater restoration of the mob site in accordance with the Title 1 Uranium Mill Tailings Radiation Control Act of 1978. Secretary of Energy shall enter into the agreement with the National Academy of Science to obtain with the technical advice for the assistance with the recommendation for the National Academy of Science for the objectively evaluating costs of the benefit of the risk associated with the various mediation alternatives, including removal of the treatment of the radioactive other hazardous material at the site with the groundwater restoration, long-term management of residual contaminants. If the Secretary prepared for the remediation plan that consists of the recommendation of the National Academy of Science, the Secretary shall submit to the Congress report explaining the reason for the deviation from the National Academy of Science recommendation. B. The remediation plan required with the paragraph A shall be completed within no later than 1 year after the date of the enactment of Floyd D. Spence for the National Defense Authorization Act of 2001, and the Secretary of Energy shall commence with the remedial act for the mob site as soon as after practical completion of the plan. C. The licensed materials of the mob site issued by the Nuclear Regulatory Commission shall be terminated 1 year after the date of the enactment of Floyd D. Spence for the National Defense Authorization Act, official year 2001. The Secretary of Energy determines the license may be terminated earlier, and if the license is terminated with the trustee subject to the available funds of the appropriated specifically for a purpose described in classes 1 through 3 or made available to the trustee from the mob mill reclamation trust may carry out. 1. Interim measure to reduce the limited localized high ammonia concentration of the Colorado River identified by the United States Geological Survey reported on March 27, 2000. 2. Activities of the dewatering, milling, tailings of the mob site. And 3. Otherwise related to the mob site subject to the authority of the Nuclear Regulatory Commission consultation with the Secretary of Energy. He is part of the remediation plan with the mob site with the requirement of paragraph the Secretary of Energy shall develop the consultation and trustee with the Nuclear Regulatory Commission from the state of Utah, an efficient legal means for the transferring all responsibility of the mob site with all the material therein. The trustee of the Department of Energy, the Secretary of Energy shall limit the amounts expended with the carried out with the remedial action in paragraph 1 and A. Amounts specifically appropriate to remedial action and appropriation act. B. For the other amounts made available for remediation under the subsection 3A. For the royalty payments received with the Secretary of Energy under subsection E shall be available to the Secretary without further operation with the carry of the remedial action in paragraph 1 until such time when the Secretary determines that all costs of the United States for the carry of the remedial action other than the costs associated with the long-term monitoring have been developed. Upon making the determination referred in subparagraph A, the Secretary of Energy shall transfer all of the remaining royalty for the general fund of the Treasury, relief for the tribe of the royalty interest retained with the United States under the subsection E. 4A. Funds made available to the Department of Energy and National Security for the activity shall not be used for the carry-out of the remedial action in paragraph 1, except for the Secretary of the Energy may use such funds for the program direction directly related to the remedial action. B. The authorized to be appropriate to the Secretary of Energy to carry out the remedial action in paragraph 1 of such sums as necessary. 5. The mob site was told after the day of the Secretary of Energy complete for the remedial action with the paragraph 1 shall sell or pay for the Secretary of Energy to provide with the general fund of the Treasury for the portion of the sales price for the Secretary of the determined result of the enhancement value of the mob site with the result of the remedial action. The enhanced value of the mob site shall equal the difference between A. The fair market value of the mob site on the day of the enactment of Floyd D. Spence for the National Defense Authorization Act of 2001 based on the information available at the date, and the fair market value of the mob site approved for the completion of the remedial action. 6.8. No later than October 1st, 2009, the Secretary of Energy shall complete the remediation of the mob site with the removal of the tailings of the Crescent and Junction site of Utah. B. In the event the Secretary of Energy is unable to complete the remediation of the mob site October 1st, 2019, Secretary shall submit a Congress a plan with setting further the projected completing of the date, estimated funding to meet the revised date. Secretary shall submit the plan if required by the Congress no later than October 2nd, 2019. Alright, Section 3406, Administration.